welcome you to the bucket courses. I'm Joanne Bungie. I chair the Community Education Council, which sponsors the bucket courses. If you will silence your cell phone, I will direct your attention to the two half sheets of paper that you have on your tables this morning. The yellow one has to do with your opportunity to make comments about this course or any bucket course. Give us suggestions about anything you have. Our planning committee is always striving to do a better job for the bucket courses, and you are a big help to that. So please, if you are so inclined, fill that out. And you can just leave it on the table or put it on the table in the hallway when you leave. Also, the other one has to do with the next bucket course, which begins next week. If you have not heard Mike Gunther lecture before, you may want to wait until the end of this class when he will be here to give you a preview of his course. Those of you who have heard him lecture before, I'm sure will want to fill it out right away. You don't need to do this if you have registered anywhere else. If you have returned Jim's email and said you want to be in the class, or if you've signed up here at the library or at Pearson, you don't need to fill this sheet out too. But if you haven't registered in any of those places, this is your chance. And we have to limit the class to 90 registrants. So if you want to get in, this is your opportunity. And now today, we're going to get right into our class because this is the day George is going to catch up. So this is the fifth and last class of our Constitution from origin to implementation with Professor Emeritus of History at Grinnell College, George Drake.
Well, with that introduction, can you hear me okay in the back? Okay, good. We should gird our loins. It's really your fault that I'm so far behind. You've got questions and so on. I'm not going to take time at the moment to mention the very one-page handout that you have, because we are actually going to look at that closely, and we're going to also look at a couple of the handouts. I hope, if we do get far enough along, that were given out previously, and I will try to be clear about what we'll be looking at. Now, you notice there are 38 pages in this document, and we're at page 20. But, I know we won't have a chance to look closely at all of the amendments, but I want to look closely, particularly at the Bill of Rights and the amendments immediately after the Civil War. We'll see what else another time. But we're at Article 6 of 7. And the sixth article, which in my little notes to myself in here, I sort of labeled a miscellaneous article. It covers a number of things. They're sort of wrapping up their business at the Constitutional Convention. It says, all debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. In other words, we're changing our form of government, our Constitution, but we still owe money. And this, if you know something about the period of the American Revolution, we had a lot of debts. Individual states had debts, and the country had debts. Some of them, of course, owed to the country we had just broken away from, England. And Hamilton in particular is going to push the issue of we have to restructure our finances. He's going to try to establish a funded debt and have the total United States take over the individual state debts, and that will become an issue because, for example, Virginia has paid its debts and other states have not. So Virginia, which is the most powerful of the states, would think that's very unfair to do that. But the issue of debts is very much on their minds. And by the way, I meant to start by saying, just as by giving credit to Mike Gunther where credit is due. When about 8 years ago I designed a course that I did sort of present a form of here called From Europe to America, mostly from England to America. That was my first effort to really engage with American history. Who did I go to help me get started? Mike Gunther. And Mike was tremendously helpful in sort of steering me toward the things that I needed to look at and know. Okay, back to the Constitution. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. This is one of the most important clauses in the Constitution. Supreme law of the land. And when this whole issue of judicial review, this is one of the elements of the Constitution that the courts will point to, saying, you know, there is an obligation of the courts to uphold the supreme law of the land. And as I think about that convention and what was going on with the states, you know, hesitantly coming together as a nation, which they were unwilling to do under the Articles of Confederation, even while they're fighting a Revolutionary War. But they've come to the point where a majority really do think we better hang together or we're going to hang separately. Well, we've got to get together. But for them to assert in the Constitution and to get past through the varying opinions at the convention such a phrase, supreme law of the land, with respect to federal law, I think is a real accomplishment. And if you're a person who feels we should have a strong federal government, if you're a person who thinks we ought not to, then you would say this is a betrayal. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So they're not going to allow state law to frustrate laws that they have come together to pass federally. So it's a very strong element in the Constitution as I see it. And then the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judiciary officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. So, again, even if you're state attorney general, you still have to swear to support the U.S. Constitution. Again, a very strong statement with respect to having an effective, and as they described it in their terms, energetic federal government. And then tacked on here, interestingly, but no religious test shall ever be required as a qualification to any office or public trust under the United States. So you're beginning to get this notion of separation of church and state. Now the background here draws on the history of Great Britain. In 1873, the Parliament of England, as it was then, they were not yet united with Scotland, passed a series of test acts. They were called test acts. And in order to be in the government, you had to take an oath to reject transubstantiation and the Catholic Church. In this period, England was virulently anti-Catholic. It's really interesting to look at the English Reformation because they're the coolest and most vacillating of all the Reformed countries. But once they take that step, and you get into the late 17th century, they are virulently anti-Catholic, and we inherit that in this country, essentially. You think about the anti-Catholicism as more and more Catholic immigrants from Ireland and Southern Europe come into this country, and the intensity of opposition to Catholicism. We inherited that from the British. So what they're saying is they're going to repudiate anything like the Test Act. At least they're going to try to be open about the issue of religion and not make religion a qualification for holding office. You don't have to swear to anything.
But
And
the
by the way,
states could.
what? Excuse me.
The states could and did.
States. Go ahead, John.
About religious preference in Connecticut, it was about 1816 that you didn't have to be a Congregationalist to vote or hold office.
And in Massachusetts, I think it's the last church to disestablish, state to disestablish the Congregational Church. Yeah. So, but probably under the United States. So yes, the point that John is making is that there were state qualifications in this period, So this is a federal position, not a state position. Good point. Good point. And in Britain, until the so-called Catholic Relief Act of 1829, they still had the Test Act in force. So Britain is going along until the early 19th century with disqualification of Catholics. Catholics couldn't even go to the universities because you had to swear against being a Catholic in order to go to the universities, which were essentially Oxford and Cambridge, University of Durham, and I think London was just getting started. So there weren't that many universities in Britain at the time. Okay, if you're willing, let me go on. I like the eagerness of what I said. Yes, move forward. Okay, Article 7. This is the ratification article. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. Okay, just a word about that process. In 1787, this is in September that they've signed the Constitution, mid-September. By the end of the year, by the end of December, Delaware, New Jersey, Georgia, and Pennsylvania have all ratified. So you have 4 states that ratify in 1787. Then in 1788, in January, Massachusetts ratifies. Delaware, Georgia, Pennsylvania. Okay, Massachusetts ratifies, Maryland ratifies, South Carolina, and Virginia actually becomes the 9th state to ratify in June of 1788. Now you remember that handout I gave you of Federalists and Anti-Federalists was all sort of aimed at New York. And New York was going to be a tough state. New York becomes the 11th state to ratify. So by the time they ratify, it's a dead letter. The Constitution is going to go into effect. And the vote was 30 to 27 in their convention. They're the last of the states to ratify at this point. North Carolina rejects it 193 to 75. So North Carolina rejects the Constitution after it's already been ratified by enough states. They decide to join the Union in November of 1789. Rhode Island, which didn't go to the Constitutional Convention, which still hasn't ratified, finally gives up without a convention, and in May of 1790 they join the Union. So though even the most recalcitrant of states are obliged, they finally feel, to enter the Union and not remain separate from being under the Constitution. All right, now I think at this point I want to refer to the handout that I gave you, which comes from this book, The Anti-Federalist Papers, which is edited by Ralph Ketchum. And I'm going to actually read this, and you can follow along. This is, as you can see from the heading, the signing of the Constitution, September 17th. This is the day they signed. And the first person to speak is Benjamin Franklin. And this is the record that James Madison had made of Franklin's speech, which I think, to me, it exemplifies not only him as the sort of, Washington's the most important person at this convention, but that Franklin is seen as the sort of patron saint at the convention, the elder statesman. He's by far the oldest person at the convention, and he's been a force of moderation throughout. And he makes this statement preliminary to the signing, which I think embodies the best spirit that you could sort of associate with that convention. He says, "Mr. President," he's addressing Washington, "I confess that there are several parts of this Constitution which I do not at present approve. But I am not sure I shall never approve them. For having lived long, I have experienced many instances of being obliged by better information or fuller consideration to change opinions, even on important subjects, which I once thought right, but found to be otherwise. It is therefore that the older I grow, a lot of people in the room can identify with this, I can, the more apt I am to doubt my own judgment." I don't know, I guess so, yeah. "And to pay more respect to the judgment of others. Most men indeed, as well as most sects and religions, think themselves in possession of all truth, and that whatever others differ from them, it is so far in error. Steele, a Protestant, in a dedication tells the Pope that the only difference between our churches in their opinions of the certainty of their doctrines is the Church of Rome is infallible and the Church of England is never wrong. But though many private persons think almost as highly of their infallibility as that of their sect, few express it so naturally as a certain French lady who was in dispute with her sister said, "I don't know how it happened, sister, but I meet with nobody but myself that is always in the right. Il n'y a que moi qui a toujours raison." In these sentiments, sir, I agree to this Constitution with all its faults, if they are such, because I think a general government necessary for us. Now there's, I think, the underlying point that does draw virtually everyone together at this convention. We've got to get a better central government. And there is no form of government but what may be a blessing to the people if well administered. So even if there are faults in this Constitution, if we administer things properly, we can have an effective government. And believe farther that this is likely to be well administered for a course of years and can only end in despotism as other forms have done before it, when the people shall become so corrupted as to need despotic government. So in other words, you folks who fear this is too strong a government, it's going to be our fault as a people if that happens, not the fault of the Constitution or the government, not being incapable of any other. Okay, I doubt too whether any other constitution we can obtain may be able to make a better constitution, a convention, excuse me, convention we can obtain, because there are some thoughts that maybe they ought to have a second convention, may be able to make a better constitution. For when you assemble a number of men who have the advantage of their joint wisdom, you inevitably assemble with those men all their prejudices, their passions, their errors of opinion, their local interests, and their selfish views. From such an assembly can a perfect production be expected? It therefore astonishes me, sir, to find this system approaching so near to perfection as it does. And I think it will astonish our enemies, who are waiting with confidence to hear that our counsels are confounded like those of the builders of Babel, and that our states are on the point of separation, only to meet hereafter for the purpose of cutting one another's throats. Thus, I consent, sir, to this Constitution, because I expect no better, and because I am not sure that it is not the best. The opinions I have had of its errors, I sacrifice to the public good. I have never whispered a syllable of them abroad. Within these walls they were born, and here they shall die. So, and it goes on, but I think we've got the essence of his speech. So, I hope, and I think predominantly this is emblematic of the sort of spirit which they came together to sign the Constitution on that day. Now, when we go to the next section here, the word, and this is where it gets really interesting, the point has been made that the Constitution is unexpurgated. And if you need any evidence of that, here you have the corrections listed. I mean, it's amazing. We have been willing, I think it's a sort of wonderful statement of the value of history and historical documentation, that they leave it as it was, as they signed it that day, and didn't go back and clean it up. And then, so we have the Constitution, then we'll have the amendments which alter aspects of the Constitution, but we can look back into the Constitution itself to see what was altered. Okay, the word "the" being interlined between the 7th and 8th lines of the first page, the word 30, and I'll talk about that in a minute, being partly written on erasure of the 15th line of the first page, the word "is tried" being interlined between the 32nd and 33rd lines of the first page, and the word "the" being interlined between the 43rd and 44th lines of the second page. No word processing here. And in fact, when they finished, they then copied this all out, just exactly the way they did, and sent copies out to the 13 states to debate. So, you know, doing all this by hand, and no effort to change the way they've done this. And then attested by William Jackson, Secretary Dunn, in the convention by the unanimous consent of the states, presented the 17th day of September, the year of our Lord, 1787, and the independence of the United States of America, the 12th, in witness whereof we hereto subscribe our names. And then you have the 39 signers. There are 55 people who came. there are 42 left, and 39 of the 42 signed. The people who do not sign, who stayed to the end, were Eldridge Gary from Massachusetts, the person who, as governor of Massachusetts in 1811, responsible for the word gerrymandering. We talked about that before. Edmund Randolph and George Mason, I think. Let me just get back here to my notes. I've skipped too many pages here. Excuse me. Yeah, George Mason and Edmund Randolph of Virginia and Eldridge Gary of Massachusetts are the three who refused to sign. Now, the only one who makes a statement is Randolph, and he's in a tough spot. He's governor of Virginia. He's the one who formally presented the Virginia plan, which has been the agenda for the Constitution, not fully adopted as it was presented, but the sort of spine of the Constitution. And he gives a little speech here, which again, Madison recorded, where he said, "I want to reserve my options." And in fact, in the Virginia Convention, when he voted for the Constitution at the Virginia Convention, Mason is a consistent opponent of the Constitution, joining hands with Patrick Henry at the Virginia Convention to argue vociferously against adoption. And Gary never does support the Constitution, but Randolph eventually does. So you can think of it maybe as 40 of the 55 who started out actually supported the Constitution. Now, I do want to read a little bit about why the 30 is inserted instead of 40,000, 30,000. A man named Gorham proposes that the basis for, this is on the last day, the basis for choosing a representative for the House should be a population of 30,000 rather than 40,000. In other words, you reduce the number of people it takes to elect someone to the House of Representatives. Therefore, a tighter connection between the electorate and the House. So that's why they've taken out, they've erased 40,000, and then in the erasure they put 30,000. And this is why I want to read this little short speech. It's the only word spoken, recorded word spoken by George Washington at the convention. He says, he rose. He says, for purpose of putting the question, he said that although his situation here had hitherto restrained him from offering his sentiments on questions depending in the House, and it might be thought ought not to impose silence on him yet, he could not forbear expressing his wish that the alteration proposed might take place. In other words, 30,000 versus 40,000. It was much to be desired that the objections to the plan recommended might be made as few as possible. The smallness of the proportion of representatives had been considered by many members of the convention an insufficient security for the right and interests of the people. He acknowledged that it had always appeared to himself among the exceptional parts of the plan, and late as the present moment was for admitting amendments, he thought this of so much consequence that it should give much satisfaction to see it adopted, and it was immediately adopted. So that's why they had to change, erase 40,000 and put 30,000 in. And it's a nice sort of intervention of Washington. It shows him a democratic sort of principle. He's pushing for a more representative and not a less representative government. Okay, here we are. We have finished the Constitution. We only have 27 amendments to look at, but I'm a realist. We won't get to all 27, but for sure we want to look at the first 10. The so-called Bill of Rights. And I've said before, and I will reiterate, that Madison and other strong proponents for this Constitution recognize that it would require a Bill of Rights. They held out. Madison kept saying, oh, there's elements in the Constitution, so surely we have enough protection there. But in fact, most states had Bills of Rights. This was not unprecedented. And I don't have any secure written evidence that Madison had promised a Bill of Rights, but it's pretty obvious that that was one of the promises that's been made, assurances have been made, let's get this Constitution passed, and we'll get a Bill of Rights. And Madison went to work on producing a Bill of Rights. And by 1789, he has produced it, and the first 10 amendments are ratified by 1791. So very shortly after the government gets up and running, we have the Bill of Rights. I'm going to, and just to prefigure where we're going to go, we're going to look at the Bill of Rights, then I'm going to ask you to take out, if you can find it, the Virginia Bill of Rights that I handed out earlier. It's a single page on both sides. And I'm going to look at the Bill of Rights first, and then you can see the degree to which that particular Bill of Rights contributed to our federal Bill of Rights. And I want to keep making the point over and over again. These folks are not working in a vacuum. They have the state constitution. They have the theories of the Enlightenment. They have the Articles of Confederation, and they have their study of Rome and Greece and other. I was asked the other day after the last class, were there any European countries that were any sort of model? And the model that they most frequently mention is the Netherlands, the republics of the Netherlands and their constitution. So there are some more current aspects of Europe that they can also point to. So I mean, it's a wonderful thing, in my view, that they pulled together, but they had a lot of help. They aren't doing it in a vacuum. So some of these amendments we have already talked about, and I'm going to, when we get to the second, I'm going to move this along, but if you still have, and that's probably in terms of everybody in this room, the amendment that most exercises us today, and where there's at least as much controversy as there could be about any of the amendments to the Constitution. But the First Amendment, huge, and when you think about it, it covers a lot. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech. Let's stop for a moment about religion and John's point. This really does emphasize that we are a messy, at least two-tiered, multiple-tiered form of government in this country. These states have a lot of sovereign power. And this federal government is an overlay on top of the states, and the question is, how much power is it going to have? How much power do the first 10 amendments have over the states? And you have states with established religions. And I'm born and bred Congregationalist, United Church of Christ these days. But my dad and my grandfather were Congregational ministers, and we think of it as a very liberal form of religion. It was the last established church in America. In Massachusetts till 1833, 32 or 33. And, had really a lot of power in that state. Doesn't have much power these days. One of the least powerful of all of our denominations, but they sure roared into this country with an awful lot of power. And so you can say this in the federal Constitution. Congress can't establish churches, but states have and do and still have them. The trend is going to be again in favor of the Constitution and the Bill of Rights, away from what has been, but the historical pattern of established churches hangs on for a considerable time. Okay, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of people peaceably to assemble and to petition the government for redress of grievances. Now, I think we know that an awful lot of our constitutional law and constitutional actions, court actions, have to do with the various amendments in the Bill of Rights. And think of this. Free speech, you cannot inhibit free speech. Money, free speech, that has been the judgment of the Supreme Court. That if I give money, that's a form of my speech to a candidate. That's free speech. In other words, you get these words, and you can't quite know how broadly they were viewed by Madison and others who are considering these words at the time, but they can't possibly anticipate the breadth of interpretation of these words in the courts. And so this is what these areas where you get these really difficult judgments. You wonder, how can the Supreme Court swing so much between conservative and liberal, and to use modern terminology. But you've got space for swing. When you talk about free speech, what are the limitations on free speech? Pornography. Generally, the courts have upheld the rights within certain limits. Child pornography is against the law, but most pornography is not, as a free speech issue. It's freedom of speech. But, you know, depending on your experience, your culture, and so on, you'll take a very different attitude toward issues of freedom of speech. I think it's ridiculous that money is regarded as free speech. The Koch brothers and I are equal with regard to free speech and the use of money. All of Iowa can't match them in terms, and I just think it's ridiculous. But, you know, you also, if you have a different perspective on this and think that people of property and money ought to have a little more sway in our democratic society because they have much greater stake in it, they have much more to lose, and so on, well, you could, I think, make a defensible argument. It would be hard for me to defend it, but they can, and the courts follow. I mean, Citizens United and so on was a fairly conservative Supreme Court, a different court. Would probably have decided it differently. And these are, when you get these 5-4 decisions, you know, you have to wonder about almost every 5-4 decision. Clearly, you have very intelligent, very well-trained, very honest people coming out on different sides of these issues. So, not to beat that one, but free speech, freedom of the press, the right of people peaceably to assemble and to petition the government for redress of grievance. Right of assembly. Can states and local communities pass laws about your right to assemble? They do. You have to get a permit to assemble and demonstrate. Is that right? Well, that's the states doing it. It's not the federal government doing it, so it isn't necessarily so tied to the Constitution. So you see, just with the First Amendment, how many issues can come up within our constitutional tradition? Jim?
But when you have an issue with the state and you appeal it, it goes to the federal laws. And so the Constitution ultimately prevails, does it not?
It goes to the question is, when you appeal from state law to federal law, and here's where, if I were a lawyer, I could be much more secure. But as I read this, the federal, they can go to the federal government when it's an issue of the federal Constitution. When, in other words, the state law counteracts the federal Constitution. So it's not, again, not so very clear. And the Supreme Court particularly can accept or reject the case. Okay? And they reject a lot more than they actually accept. But yes, there is that pattern. And a lot of people would argue that shouldn't be the case. The states ought to be freer in that regard. Some of us would argue the other way. Well, I'm going to have to stop in about 5 or 6 minutes, so I'm going to move on. Can I skip the Second Amendment? We talked about that. Okay, Amendment 3. We can do this pretty quickly. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Okay, so there's an English background. The so-called Petition of Right of 1639, Charles I had been quartering troops in private homes. England was not at war at that time, and in the rebellion, growing rebellion, which was going to lead to civil war against Charles I, Parliament got him in a corner and got him to agree to the Petition of Right, which contained essentially this phrase, that you can't quarter military people on civilians in peacetime. But in wartime, that's still, as you can see, the way it's written, it's still possible. If the federal government does it in a prescribed manner. It's got to be laid out. You can't just willy-nilly do it. But generally speaking, most of us are pretty safe from soldiers being quartered in our houses and having to feed them and so on.
Was that during the Civil War?
Yeah.
I think it did. Jim's a military historian. The question is, when did we allow troops to be quartered on civilians?
Well, the Civil War is probably the best illustration of it happening, particularly in Sherman's March to the Sea. That had a lot to do with provisioning and providing shelter for troops, and most of the time it was done under the authority of the field commander.
Okay, so the question, and Jim's answer, for those of you who might not have heard it, is during the Civil War, particularly Sherman's March to the Sea, this was done, and under the provisions provided by the field commander. Yeah, Eric.
And of course, they were in a foreign country at the time.
Eric's addition is they were in a foreign country at the time. Okay, Amendment 4, search and arrest
Before we
warrants.
move on,
Oh, yes, James.
where and when has it been prescribed by law as to how federal troops could be housed in private? How is this last phrase enacted?
How is the last phrase enacted? I'm going to turn to Jim. My guess is it's going to be that you do have laws that military commanders in time of war can do this, but.
Yeah, that's true, and that's covered under the UCMJ, but it's not a provision that's much used or accomplished. Most of the time, military organizations want to have their own control of their supplies and sustenance so that troops don't rely on the countryside. One, it can get out of hand, and two, it could be dangerous to those troops.
So Jim's response is that, yes, there is federal law that allows it in time of war, but it's very cautiously exercised by the military because it's most usually not to their advantage to use it. Emily?
Yeah, just to advise the group, there are cases moving through the courts today citing the Third and Fourth Amendment in regards to the increasing militarization of the police in the United States and certain police groups moving into the homes of private citizens in order to take advantage of their position vis-a-vis some other private home.
Okay.
A crime maybe suspected.
So Emil's, you probably heard it because it's coming from the back, but Emil's point is that there are court cases now, things moving through the courts, more often with the police than the military, where the police, as a matter of surveillance or something like that, are moving into one home to observe another. So it's not a dead letter, and he says that these are Third and Fourth Amendment issues that are going to the court. And, you know, this sort of emphasizes the fact that almost all these amendments do get into the courts, probably more often than the actual Constitution itself. Let's just do Amendment 4 and then we'll stop. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, second half, easy enough. No general warrant. The warrants have to be specific for searches or seizures. But, just, you know, again, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Wiretaps, electronic surveillance. I mean, there's no way that the makers of the Constitution or Madison could have anticipated the means of search and, you know, what wants to say, observation, or whatever word you want, surveillance, available to us today, which then produces a whole series of new cases that have to be adjudicated by the courts as to whether these come under the Fourth Amendment or not. And so, again, you can see why the Bill of Rights, these amendments, are so often the center of court cases. So let's take a break. We're almost halfway through the Bill of Rights. You're doing well, folks. I commend you.
Thank you for taking your seats, everyone. And now we'll finish off with the second half of George's course on the Constitution. George Drake.
Okay. Fifth Amendment, again, a lot here. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. So there is such a thing as martial law, but most of us are under civil law. Now, the one you're going to ask this question, and I haven't got an answer to this, except or on a presentment or indictment of grand. Oh, I think we're okay. In other words, in presentment and or indictment of grand jury are two different things. This is habeas corpus, is the way we know it. You can't imprison or try without cause shown. And so it's either through indictment of grand jury or presentment or a charge. You have to have a charge. And so this is obviously a huge right. Governments can't just willy-nilly imprison you for no cause given. So there's habeas corpus there. And then with the exception being military law, martial law. Nor shall any person be subject for the same offense to be twice put in jeopardy, double jeopardy. Most of us are familiar, we've seen movies about it and so on, so this one I think is an element of our Constitution we're very familiar with. The jeopardy of life or limb. Nor shall be compelled in any criminal case to be witness against himself or herself. So we talk about taking the fifth. This is taking the fifth. You do not have to be a witness against yourself. So when you take the fifth, and that's, of course, people immediately say, oh, this person must be guilty because the fifth. You don't want to give testimony against yourself. Well, you may be guilty, you may be not, but you certainly have the protection of not being a witness against yourself. Nor be deprived of life, liberty, or property without due process of law. Now this has turned out to be one of the stickiest and most difficult parts of this particular amendment or of any part of the Constitution. Because this has, by the courts, been interpreted as an equal rights amendment. There's no statement of equal rights here. It's put in these 18th century terms of Locke and so on. Life, liberty, or property. We've also talked about pursuit of happiness in the Declaration of Independence. But this is the part of the Constitution that gets interpreted as equal rights, so that issues of same-sex marriage, women's rights, etc., tend to come under this part of the Constitution. And in this book that Lola loaned me on the Indivisible Constitution, Lawrence Tribe makes a big issue of this as to how extensively this has become interpreted by the courts as an equal rights aspect of our Constitution. So, and how far can you go with those words, life, liberty, and property? Liberty, life, yeah, equal rights within of liberty and life and so on. So you sort of see how it goes in the direction of equal rights. Same-sex marriage, etc. The rights that we are in the midst of today, and very much current, is affected by this part of the Constitution. Nor shall private property be taken for public use, eminent domain, without just compensation. So, yeah, they can come along and they need to build a freeway or an interstate through your farm, and you've got, if the state or the federal government does this, it can be done, but you have to be justly compensated. It's always an issue of what is the just compensation. When you don't really have much bargaining power or leverage. But it again is a big aspect. So if I hadn't been so slow on other parts of the Constitution, we'd have a lot of fun with the Fifth Amendment. But it's a huge amendment, a huge amendment. So let's go on. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Now, this, of course, what is speedy? when the courts get clogged up. Anyway, it's clearly an issue. By an impartial jury of the state and district wherein the crime shall have been committed. That's important. But of course, there also are petitions for change of venue. Sometimes if there's too much publicity within the area where the crime was committed, then there has to be some sort of judicial action to move it. And, okay, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. Again, here comes something related to habeas corpus. You have to be informed. You can't just say there's just a general charge against you. What is the charge? What specifically is the charge? And you have a right to know that. To be confronted with the witnesses against him, witnesses have to be in open testimony. And of course, this gets into the issue that you hear about all the time. As lawyers are preparing the trial, the prosecution is supposed to make available to the defense the evidence that they have. And frequently that's not done. And so you get a basis for a retrial, mistrial, and so on, when they discover that key evidence that they had at the beginning of the trial was withheld from the defense. But this is part of our rights. To have a compulsory process for obtaining witnesses in its favor, so the state has to help you to get witnesses for you, and to have the assistance of counsel for its defense, public defenders. So public defenders are part of our Constitution. Okay, you're letting me go on. Amendment 7. This is an interesting amendment. One of the issues that was constantly raised by the anti-federalists. So let's read the amendment, then I'll get into that. In suits at common law, where the value in controversy shall exceed $20, $20 in 1787 versus $20 in 2014, but still there, so it means almost every case, every case. The right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. This is trial by jury in civil cases. Trial by jury in criminal cases was within the Constitution, and Article 6 simply elaborates that. But there was nothing about trial by jury in civil cases in the Constitution, and yet many states, if not most, had trial by jury in civil cases. So the anti-federalists keep hammering, no trial by jury in civil cases, our rights are being deprived by this Constitution. Individuals are being overrun by this federal government. So here it is in Article 7, very explicitly, right of trial by jury in civil cases. Okay, the 8th Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. I challenge us to have uniform standards for any of this. Excessive bail, what's an excessive bail? $1 million, $2 million, I mean, there are bails like that in really heinous cases where they're very fearful that someone of wealth is going to flee the country and so on. They can impose, and clearly it means that the judge or the court has to justify that. You can't just do it without some justification. Excessive fines, what is excessive? And then cruel and unusual punishment. Is the death penalty cruel and unusual punishment? Yes. Certainly in the lines of the 18th century people, no. I mean, their capital punishment is all over the place. I mean, we're coming out of an era where there wasn't much law and order or law enforcement, so the big enforcement issue is capital punishment. You know, in the 18th century, capital punishment for theft, pickpockets, executed. You're trying to put fear of capital punishment in the populace to get them to obey the law, because you don't have very good other ways of doing it. And as we emerge from the 18th century with much better law enforcement, much more capable law enforcement, you know, at what level is there a cruel and unusual punishment, particularly capital punishment? I mean, I think there's no question that people can try to bring constitutional cases under this element of the amendment, 8th Amendment, that, you know, capital punishment is cruel and unusual and should not be in the case. So in other words, this is a very, very broad amendment. Shane?
Has there ever been any federal legislation in terms of defining what capital punishment methods can be used? Hanging, poison gas, decapitation, any of that?
The question is, has there been any federal laws defining what is allowable and not allowable as a form of capital punishment? And we know there are many, many forms. The simple answer is I don't know. I suspect that this has been largely a matter of the states, state laws, not federal law. But there are federal crimes, and there is federal, do we still have federal capital? I think we do. Yeah, sure. So I just don't know. Does anybody in the room? Because I'm pleading ignorance here, so. Ken?
Tennyson's RISPA produced a reaction of banning the hanging in chains.
Now, the first part was,
As Tennyson's poem RISPA produced a reaction in the British government that they banned hanging in chains, which was the idea of hanging somebody with chains around them until they died and then...
yeah. So if you're talking about the British government having prohibited hanging in chains, as Ken's comment. Well, all right, rather than, that's something Jim?
The current trial for the terrorist is capital. They're considering capital.
Yeah, terrorism is a federal capital crime, yeah, is Jim's comment. So, rather than hang us up in our mutual ignorance, and with a little help, we will go on. But that's something that wouldn't be very hard to look up online, I think. But the overall thing is I think the definitions of the forms of capital punishment are within states, and of course, some states outlaw capital punishment, and some states do have it. So you can see, as a society, we're moving more and more in the direction of eliminating capital punishment. And I think, in other words, what that says to me is our society, as it reflects about what is cruel and unusual punishment, is increasingly deciding by state that capital punishment is cruel and unusual punishment and should not be exacted within our legal structure. Okay, now we get into some really open-ended amendments. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What does that mean? The enumeration in the Constitution of certain rights, okay, we've got some of them to write, but we may have missed some. Shall not be construed to deny or disparage others retained by the people. Now here's the libertarian element coming forward. We're not going to limit our rights to those that we put down. There are other rights that we might not have thought of that are hard to put down, and therefore the absence of mention of those rights does not eliminate those rights. So think again what the courts can do with this. And in the tribe book, he says this is really the most open arena for the courts and litigation and so on that possibly can exist for us. Because as you try to ferret out those rights that people have that haven't been enumerated. But it's a good provision because all of them recognize we're fallible human beings. We can't cover everything. Life changes. And they do. They know there's going to be change. They can't possibly anticipate the velocity of change and so on, and the extensiveness of change. But they know there'll be change, so they're trying to end this to cover themselves. And then Amendment 10: the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Again, a states' rights amendment and a libertarian thing. In other words, if you don't prohibit something in this Constitution, then it's in the rights of the states or the people. In other words, a vast area of rights and powers that are not covered by the federal Constitution. We're not just a government from the top down, we're a government of states, and we're a government of individuals. And again, I'm so thankful to Lola for loaning me that book, because Tribe talks about right of private government. We govern ourselves. Everyone in this room governs a life, your own, and sometimes the lives of your children, and so on. And sometimes your husband. I'm not saying the other way around. No, it works both ways. We govern each other. But there's a lot of government going on in our society that is outside the purview of the federal government or the state government. And this Constitution shall not be deemed as an intrusion, an erosion into that, except for the fact that if we're going to live in a society, we have to have certain rules so we don't trample each other. And again, this comes right out of that Enlightenment philosophy of, in the state of nature, we have all these rights, but then we discover in the state of nature that my right interferes with Doug's right, and his rights are beginning to interfere with mine. Can we live civilly, or are we going to beat each other's throats because of the infringement on each other's rights? Well, maybe we better establish some common elements of law and order in our society so we can live together and then be free to govern ourselves within our own more restricted sphere of influence. So here in this amendment, and this is wonderful 18th century stuff, natural law stuff and so on, that yes, we have this government, but we're going to limit it to this social interaction that we have, not to as much to our private lives. And so we get into that issue also, how much should government interfere with our private lives? How about the right of the unborn versus the right of a woman over her own body? And here you've got two rights that conflict. I mean, the right of the unborn, how can you possibly limit the right of the unborn to have that opportunity for life? Yet, women find themselves, oftentimes through no fault of their own, in a situation where they are asked to produce that life when they have no desire to do it, nor even the ability to sustain that life afterwards. So shouldn't that right be uppermost? And so you get Roe versus Wade and the issue of right to life over the rights of individuals in their own body. So, and they're almost irreconcilable. And that's one of the reasons that's such a huge issue in our society. So almost irreconcilable. How can you pit those two against each other and resolve it in any sort of fair and equitable way as the issue, as we confront it? So that's a place where government and Constitution and so on begin to get very, very close to the individual's rights and the most basic rights of life and so on. So, but the Constitution makers recognize that you're going to come against those issues. They don't define it any more than they do in Article 10. And yet it's a very important article, I think, reflective of the thoughtfulness and effort that's made by Madison and others. Now, if you allow me to move on, because I've got to stop in about 11 or 12 minutes, I just want to mention, you'll wonder why I'm doing this, Amendment 27. It's a strange amendment. The last amendment to the Constitution, May 1992. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall intervene. So again, Congress can't affect its own salaries. This amendment would have been the 11th Amendment to the Constitution, just after the Bill of Rights, back in the 18th century. But it was finally approved by the state of Michigan, which represented the 3/4 of the states, in May of 1992. So it was floating around for a couple hundred years, and finally gets added to the Constitution as the 27th Amendment. So I'm mentioning it now because chronologically it would be the next amendment to the Constitution. I'm going to go quickly through the 11th and 12th Amendments. We already talked about the 12th. That's the one that came about because of the disputed election of 1800, when they had 36 votes in the House of Representatives before Thomas Jefferson was finally elected over Aaron Burr. And those are the days when you had two votes, both for president, and you came out, the person who came out second was vice president, the person who came out first was president. Trouble was nobody came out first or second, they were tied. And they tied for 36 votes. And so they, very quickly, 1804, you have this amendment which says, but essentially, when you're voting for both the president and a vice president, you separate the votes for president and vice president. That's what that. The 11th Amendment is an effort to restrict the judicial powers of the federal government with respect to lawsuits within states or between states. So I'm gonna, if you'll allow me, I'm gonna go, and I think, I said I could do this, and I think I will. I want to do the 13th, 14th, and 15th Amendments, the post-war Civil War amendments. If you saw the movie Lincoln, you saw the 13th Amendment movie. And most of us in this room have seen it, but essentially what was happening there was to try to get the abolition of slavery through before war actually ended, and then you had to deal with the Confederate States coming back into the Union and as to whether they would approve an amendment to abolish slavery. So that's part of the dynamics of that movie, of Lincoln pressing the case before the end of the war, and the whole issue of was he delaying the end of the war, and peace consultations with Southern representatives in order to get this amendment through. So, but this is the one that builds the Emancipation Proclamation was a wartime measure, justified entirely by Lincoln's position as commander-in-chief. He judges that the North cannot win as long as the slaves of the South are there supporting the infrastructure of the Confederate Army. We will deprive the Confederate Army of part of its power by removing its slaves. And some of them may escape and come and help us. We'll try to, hasten that. So it'll add power to us and take power away from them. So it was a wartime act which could not endure beyond the war. Therefore, you needed an amendment to the Constitution to bring that about. Now, what I want to do here, and we've got about 8 minutes left to do it, you have a handout that I've given you, which is the one that says civil rights and voting rights. And what I want to do here, the 14th Amendment is a long amendment. It deals in part with the winding up of the Civil War. It's passed in July of 1860. It's ratified in July of 1868. So it's a post-war measure which deals with civil rights, but it also, in many of its provisions, deals with how to restructure the relationship with the Confederacy within the federal government, and essentially depriving strong pro-Confederates of rights under the Constitution, voting rights and so on. But when you read these amendments, 14th and 15th, 15th is the one is a voting rights amendment, the 14th is a civil rights amendment. So let's look at section 1, which is really the most important. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property, coming back again, without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. Now here you have equal protection actually inserted into the actions of states. So you're finally getting, and that's one of the things that's used by the Supreme Court to say, well, equal protection really was part of the Fourth Amendment as well. So you're getting closer to this equal protection issue. All right, you read that. Now turn just quickly to the 15th Amendment. The right of, and that's on page 30, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous conditions of servitude, The Congress shall have the power to enforce this article by appropriate legislation. And there was legislation in 1870. You look at those, and then you say, how did Jim Crow happen? How were the rights of blacks to participate in the political process denied for almost 100 years? And what I've attempted to do in this handout is explain that. So what I'm going to do is sort of not read it verbatim, but sort of go over what happened. It's essentially a reaction against Reconstruction. As long as the Federal Army was in the South, occupying the South, as I said, enforcing the 14th and 15th Amendments by bayonets, it worked. Blacks are voting, blacks are elected, but by the late 1870s, there's a general revulsion, obviously in the South, but in the North, about military occupation of the South and forcing this. I mean, the emotion and trauma of the Civil War is beginning to recede. We're beginning to think of ourselves as one nation again. How do we come together as one nation? Well, not by the force of an army occupying half, well, not geographically half, but essentially half of the nation. So in 1877, Rutherford Hayes withdrew federal troops, and you no longer have federal enforcement. Now, also think of this pattern. Voting rights have been states' rights, right from the start. How could the federal government get into this? It was a provision in the Constitution where the Constitution guarantees a Republican form of government in the states. So the federal government comes in and says, you don't have a Republican form of government, our Constitution says we should guarantee it, therefore we are going to impose restrictions on voting rights and civil rights within the states. Taking away the power of the state. I mean, they really are taking away powers that constitutionally have been part of the state. So it's the federal government taking an action that imposes federal standards on electoral process. And you can see where within the DNA of the society, the matrix society, there's a revulsion against federal government invading states' rights in their area. So you've got that as a precondition. And then you get two Supreme Court cases that are going to dismantle the 14th and 15th Amendment with respect to civil rights and voting rights. It's a conservative court, the country going through a kind of conservative phase with respect to getting back to the original idea that states have control over their electoral processes. So you get two cases. One is the Slaughterhouse case, and that's at the bottom of this first page. In 1873, a 5-to-4 majority declared that the phrase in the 14th Amendment, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, omitting mention of state citizenships, meant that there is a distinction between national and state citizenship, and the former is not necessarily preeminent. So you separate state and national citizenship. Oh, their national rights are preserved, but that doesn't say anything about their state's rights, the rights within the state. So the dissent argued against that, but they were defeated. So you get this separation of national citizenship and state citizenship in that case. Then in the Crookshank case, 3 years later, the majority ruled unanimously that the Constitutional Amendments and Enforcement Act of 1870 applied only to statutory discrimination by state governments, not discriminatory actions. Okay, you can't pass laws to restrict the rights of black people to vote, but you can impose literacy tests, you can impose a poll tax, you can impose this, that, and the other thing, and you haven't passed a law, it's just your actions are a little bit discriminatory, but so be it, and you're going to phase right into Jim Crow. Which then is going to require, as both, and I didn't read this element of the 14th Amendment, but both the 14th and 15th Amendment say the federal government can pass laws about this. So in 1964, you get the Civil Rights Act, and in 1965, you get the Voting Rights Act, which come along and impose again federal restrictions on the states in these areas. And they have stuck, sort of, until the current Supreme Court, which took away Provision 5 of the Voting Rights Act, which is the power of the federal government to come in and make the states, on an annual basis, I think, justify their voting, what they're doing with respect to voting. That's gone now, so you're beginning to get issues of citizenship and so on that are beginning to, we think, at least I think, beginning to encroach on the right of some people to vote and take action. Anyway, we haven't talked about the right of women to vote. A lot of things in here, but I think most of if you look at the amendments, most of them are fairly clear. I think we've dealt with some of the more difficult ones. And I find the 14th and 15th Amendment, it's just mind-boggling how you could have that in our Constitution and end up with Jim Crow, but we did. And there are reasons why it happened, even boggles the mind. So, thank you very much for your patience. We almost completed the task, but not quite.
I wonder if you comment a little bit on Ben Franklin's remark there about, the government may be blessing the people who've administered well and believe further that it's likely to be well administered for the course of years, can only end in despotism and corruption. Can you talk about his fears and relate that to where we are today?
You know what I'm going to do? I'm going to turn to Mike, who is a Ben Franklin guy. When I'm talking, it's his speech at the Constitutional Convention. And Mike actually has Ben Franklin quite a bit in his teaching. So, do you want to say one word about that, Mike? The question is about despotism.
In his, on the day of the signing, he wrote, and I'll just quote the one sentence. In these sentiments, sir, I agree that the Constitution, with all its faults, if they are such, because I think a general government is necessary for us, there is no form of government but what can be a blessing to the people if well administered, and believe farther, that it is likely to be well administered for a course of years, and can only end in despotism, as other forms have done before it, when the people shall become so corrupted as to need a despotic government, being incapable of any other.
Sorry, Mike.
No, I think that's a great quote. It would take a long time to unpack because there's several ideas. And just as I was listening to it, one is a kind of very Enlightenment idea that Franklin shares with his friend Thomas Paine, which is very different from the older view, which is that government is not a necessity because of the evil and depravity of human beings, that society itself without government can be a good thing. And so there's this Enlightenment ideal that starts to question, it's not anarchy, but questioning all government, just saying that it's not necessary. Human fulfillment can be found in the realm of society, and civil society, and that government is only useful in terms of if it's well administered or well designed. So there's that kind of part of the quote. But the longer one about whether or not it's up to an informed citizenry, that if citizens become corrupt, apathetic, if they aren't educated to participate in democracy, that they will get the government that they seem to deserve, quote, despotic government. That's one that you see a lot with the Founding Fathers. And it leads to this push for universal education, and the idea that it's one of the scary things about a republic is that it is in the shoulders of voters to lead it that way. So that probably doesn't answer your question, but it just...
Well, can you relate that to where we are today?
Where we are today.
Well, we've got to stop, but Franklin's a realist. And I think that statement is a statement of not only of a very broad, wide-spirited person, a very intelligent person, and a very wise and experienced person, but it's a statement of a person who knows what human nature is capable of. And the question is whether we're there today. I don't think we are, but I don't know whether we're no more divided as a society today than we have been at certain junctures in our past. And we fought a civil war as a divided society. We aren't there. But yeah, we are at a stage of greater division than often has been the case.
Okay, thank you.
Lola?
On what basis are incarcerated people and then after they're released from prison deprived of voting in some states?
Lola's question, which relates obviously to contemporary issues in our own state of Iowa, where in fact there have been charges against ex-felons who voted, or at least one. The question is, on what basis do states deprive released felons of the right to vote? And I'd say it's on the basis of states govern their their voting laws. And the question is whether that, if you brought a case, you'd have to say this is a violation of the U.S. Constitution. I'm not enough of a lawyer to argue whether it is. Because when a state does violate the U.S. Constitution, they can go into the federal courts. But it's really essentially state practice and state law that affects that. Okay, Joanne says I'm going over.
Let's stay up here.
I guess I should stay.
Here's your total.
Oh, him. As secretary.
Get the mic closer.
As secretary, I have been appointed by this assembly to present to you, Professor Drake, this document of appreciation. We, the people of the bucket course, the Constitution, in order to send a more perfect thank you, establish your recognition, ensure our message is fully understood, provide for the common understanding, promote the general gratefulness, and secure the blessings of friendship to ourselves and our professor. To ordain and establish this message of gratitude for the course, the Constitution. Attest, Nisha Worley, Secretary. Done in convention by the unanimous consent of those present, the 12th day of March in the year of our Lord, 2014, whereof we have hereunto subscribed our names.
Nobody says thank you like Nisha does. Thank you, Nisha. At the beginning of the class, I called your attention to the sign-up sheet for our next course, which begins next week. And Professor Mike Gunther has dropped by to give you a little preview of his course. So please welcome Mike Gunther.
Good morning. So my name is Mike Gunther, and I teach in the history department at Grinnell, along with George. I teach environmental history, the history of science, and British history. And the bucket course I'm going to teach starting next week is called Science and Society, from the age of Newton to the age of Darwin. It's a class I'm actually currently teaching. I just came from there on campus today. So it'll be 4 sections. It's a history of science, but it's one that's designed, I think, to capture the imagination, hopefully, of my students and hopefully of you. It's a class that tries, maybe in some ways, the way that George tried to make the Constitution, not only just a timeless document that speaks to all ages and all peoples, but a document probably filled with complexity and drama. I'm sure over the course of the weeks here, you've been exploring how these words take on, as we just heard a second ago, surprising, shocking meanings at different times. There's all these kinds of twists that are behind the Constitution. And in the same way, science, sometimes all you hear about are the end results. You hear about kind of famous scientists or their equations and their laws. And what we'll do over the 4 weeks is kind of try to give you a sense of the drama, the personality, the challenges, the emotion even that goes sometimes into the field of making knowledge in science. And especially the way that intertwines with society. I kind of firmly believe, as someone who studies science a lot, that it's hard to separate science from its time and place. That scientists, the techniques they use, the ideas, even how they organize themselves in communities, are very much shaped by society. And in turn, society often looks to science as a model for how to organize people, how to apply new techniques, how to be objective, how to create new knowledge. And so over the course of the 4 weeks, we'll look at that through 4 case studies. So one of the challenges when you teach the history of science is how do you teach it? Because no one really, I should say no one, but it's hard to teach just all these different fields, kind of marching along in time, kind of history of each discipline. And especially some of you might not have a background in science or might not be interested in knowing about the history of physics for 200 years. That's true with my classes on campus. I have students who are physics majors, psychology majors, art history majors, English majors. And so the way that I teach it on campus, the way I'll teach it here is we're going to look at 4 case studies, 4 techniques of science that we're going to focus on over the course of this 200-year period. So the first one will be experimentation. Why did scientists, starting with the scientific revolution, decide that experimentation was the best way to produce new knowledge? What does it mean to do an experiment? And most interestingly, why did the rest of the society get very interested in the idea of experimentation as a technique to teach people? We'll talk about like children's literature and the way it starts to adopt forms of experimentation as ways to teach children. Experimentation in the industrial realm with the rise of the factory system, the idea of using experimentations in machines, the Enlightenment. So we'll kind of explore, each is kind of a story in a sense about how a technique pioneered by science captured the imagination both of scientists and society at large. The second one will be quantification. Why turning everything into numbers, measuring things, kind of again fired the imagination of scientists and people. So we'll talk about the metric system. And in each of these we'll explore some different examples, kind of case studies, the people and the projects that kind of captured the era's imagination. And the third one will be classification. This is something that you might think about with taxonomy and biology, but almost every science, often one of the first steps is to create a new nomenclature, create a system of organizing things. In my class today, we were reading an essay by Luke Howard about the classification of clouds. You have cirrus and cumulus and nimbus. Almost every field began, including meteorology, with this attempt to basically create some rational classification for then exploring the deeper patterns in nature. So we'll talk about that technique and how that got applied into the social world in ways that sometimes were also insidious. We'll talk about racial and gender classifications and how that got embedded into the legal system and so forth. And then the final class will be one that topic I particularly like and I think is a little surprising, which is visualization. Scientists often draw, they use images, they visualize even data in terms of plotting it out, seeing relationships, using mapping techniques, graphing and stuff. So we'll talk about the world of drawing, visualization, and arts and how that's helped scientists create new knowledge and again kind of spurred parallel efforts in society to use these techniques to kind of understand public health, understand education, understand social phenomenon, using kind of graphing techniques, mapping, things like that. So, so I'll stop there, but that will give you some idea of what the class will be like. We'll look at these 4 case studies and try to ask the kind of question, what does it mean? What did modern science do that made it the most powerful and respected form of knowledge? And how did those techniques shape society in certain ways? So that'll be the theme of the course. So, I'm sorry if I've gone on too long.
Thank you very much, Mike. If you have not yet filled out your little yellow sheet giving your opinion of the current course or any other suggestions you have for the bucket courses, remember to do that. And if you have not registered yet for Mike's course, which begins next week, please feel free to do that. You can leave your papers on the table or put them on a table in the hallway. And we'll hope to see you all back again next week. Thank you for coming. Have a happy spring.